Can someone sue for a visa denial at the US Embassy? Please subscribe before we continue. As you know, ladies and gentlemen, most people, when they get their visa denied at the US Embassy, they don't have much recourse except maybe refiling or doing some other steps. But in certain cases, people cannot even refile. And there is a concept on non-reviewability that applies to US Consulate, where once they make the decision, you cannot go back and say their decision was no good, or you appeal it, or if you want to basically kind of try to change the decision through an appeal or sue in a federal court, you couldn't do it under the doctrine of consular non-reviewability. Okay. Now, this case just came out last month, and I just was reading about it when I was doing my research, and this case is came out on the Ninth Circuit Court. Ninth Circuit Court includes like the District of California, etc., but not everywhere. But this decision is very, very interesting because this is a situation. What happened? This person here who's suing is a Sandra Muñoz, and she is suing the government for denying a marriage petition to her husband in El Salvador, if I'm not mistaken. And what she's saying is that basically they are denying him on reasons. The denial was based on reasons to believe that he was any alien. Okay, basically this is the code 8 USC 1880. Any alien who has a consular officer or attorney general knows or has reasonable ground to believe seek to enter the United States to engage solely, principally, and incidentally in any unlawful activity is inadmissible. This is really a catch-all provision, okay, by the way. Let me kind of rewind a little bit here. What happens at the U.S. Consulate, jurisdictions are limited. Many things are limited, right? Because of the fact that it's outside the United States, although it represents the United States. And this provision under the USC 1180, subsection A3, A2, can really apply to anybody if the U.S. Consulate officer just believes that this person will be engaging in some kind of criminal activity. In this case, I will explain, this case is very interesting because it seems like there was a very prejudicial kind of way of looking at it, because he had a bunch of tattoos on his hand, and they believe he was in a gang. And unfortunately, or fortunately for Muñoz, Sandra Muñoz, she was able to prove that that should not be good enough. And she should have a right to fight this, which, if you look at the doctrine of non-reviewability, you cannot do. The reason the Ninth Circuit Court allowed this is that it basically goes against her fundamental right as a U.S. citizen. So we need to really distinguish, because don't think that every case you will be able to use this, because this one, they distinguished it. They didn't really kind of repeal that law or anything like that. Only thing they did is they went ahead and distinguished this case from other cases on the fact that she is a U.S. citizen seeking admission for her husband, and they were fundamentally infringing on her constitutional rights. So they basically, the Ninth Circuit concluded that, okay, here let's see. They concluded that where the adjudication of a non-citizen visa application implicates the constitutional rights of a citizen. So there should be some kind of citizen involved. The question is, who is a citizen? Well, a company is also a citizen. Can they use that if the cases? So that we will decide later, but an argument can be made that a company should be able to also sue the government if people are denied based on that section or other sections also maybe. But you have to fall into under the Ninth Circuit, because that doesn't apply to other circuit courts. Okay, so for those who understand a little bit, I will talk a little bit maybe in another video how the circuit courts work. But since we are in California, this will apply. But you cannot deprive a citizen of that interest of due process. Due process clause in the 14th Amendment and the Fifth Amendment, I think. And that is a part which is very, very interesting. So by them saying this, they're basically saying that, hey, you could sue in a federal court. For those who don't know, many immigration cases we can sue in federal court, including H-1Bs, denials, including cases of delayed writ of mandamus, which I have filed a lot in the early times of my career, and now I don't do them anymore. But this is a very interesting decision because it goes to the fundamental rights of a citizen of bringing their spouses to the United States. And I had a case lately, it took me almost 5 years to actually bring that person here because they keep denying it for no good reason. And that case came like 1 month after I won that case. A very interesting case. Hopefully one day I'll have her testify on this. This was an interesting case. She basically, most of the lawyers kind of gave up on it, and I took it and we kept fighting it. Ultimately, she got her husband got his visa and came here. So this case is opening a lot of possibilities, ladies and gentlemen. This is something that we need to really kind of dissect, because if we use a company as a citizen, which they are according to the law, can they sue if their employees are denied under their visas? Now the question is, if you look at the Ninth Circuit, they really didn't really attack the law completely. They basically attacked that part where there was a US citizen involved. And it was a fundamental right, which is marriage, of course, right, to pursue happiness, etc., etc. So will that work for a company? Well, there's a question mark here. Well, if someone wants to try it, they should, but obviously an H-1B is a non-immigrant visa. It has other rules attached to it, for example, and the doctrine of consular non-reviewability is a very interesting doctrine that I have never mentioned that before, but although I knew about it, but now it seems like it's not that iron shield. And if you look at the judge, they even mention that. They say, hey, you can't just be hiding behind that and deny someone based on the fact that you feel that person is to be denied. And again, ladies and gentlemen, this is Sharp Raleigh. Before we continue, please subscribe to our channel and share it, like the videos. We're going to start some very interesting lectures soon on immigration. But today we are talking about this case of Muñoz versus, am I pronouncing the name right, versus the U.S. Department of State, which is the U.S. Consulate. The case was El Salvador, and we are talking about a situation where a husband was denied his case, and his wife is a U.S. citizen, in this case Sandra Muñoz, and they won. So now the interesting part is that denial really kind of is a very unfair, just because of some tattoos. And the part that is bothering a lot of people, of course, the tattoos were Christian tattoos. So now let's see how things are going to unfold from that case. I think there will be a lot of lawsuits because a lot of people were denied wrongfully. And if you're in the Ninth Circuit, you might want to consider that. Check with the lawyer who filed a lawsuit. Or now, hopefully, the USCIS will, the Department of State will amend their their manuals to reflect that case, hopefully. But since it is only the Ninth Circuit, we don't know yet. But again, thank you so much for listening. Any questions, feel free to reach out to us, 510-742-5887. Anything I told you today is my opinion. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. Good luck.